webinar. You asked me to give a presentation on the report that we did at the last international conference of the Red Cross and Red Crescent, which took place at the end of last year. And every international conference of the Red Cross and Red Crescent, the ICRC publishes a report called IHL and the Challenges of Contemporary Armed Conflicts. Now, this report is over 80 pages long, so I thought I'm not going to speak to all of the aspects of the report because it really contains many subsections and it sort of goes through the panoply of challenges that we have seen over the last 5 years since the last international conference. What I thought I would do is to, first of all, talk about two aspects of the challenges of contemporary conflicts in the sense of what characterizes conflicts, which is on the one hand, old weapons, massive destruction, and on the other hand, new technologies of warfare. And then in the second part, I was going to talk about the main challenge that we have seen forever in international humanitarian law, which is really the challenge of compliance. And then thirdly, I was going to speak briefly to what can be done. So to the first part and the challenges of contemporary armed conflicts. And I thought, okay, which ones do I choose out of all of those that are in the report? We have today over 120 armed conflicts classified at the ICRC on the basis of the legal criteria in about 60 countries. So that's about a third of the world almost, being subjected to a situation of armed conflict. We have over 100 non-state armed groups involved in these conflicts. And we have to remember that although today we think a lot, and rightly so, and we have to think about international armed conflicts, the vast majority of conflicts remain non-international armed conflicts. Sometimes states are afflicted by many non-international armed conflicts in one territory, such as situations like in Myanmar, in Colombia, and in other parts. So what characterizes these conflicts in a way is the continuous widespread destruction that we see from weapons, in particular in urbanized conflicts. And of course, the world is urbanizing, and so conflicts are also urbanizing. And the use of explosive weapons with wide area effect, such as wide area effect artillery, mortars, large bombs with large explosive loads, can really cause huge devastation in areas, in urban areas or in populated areas where civilian objects and civilians are co-located with combatants and military objectives. And that's what we see, what we saw in Mosul, in Aleppo, in Raqqa, in Mariupol, in Gaza, and in all these really devastating conflicts. And it raises the question of the balance between military necessity and humanity that exists in the rules on the conduct of hostilities that are the rules that restrain the conduct of hostilities. So the way conflicts are fought, and in particular the principle of distinction, so distinction between combatants and civilians and between military objectives and civilian objects, the principle of proportionality, whereby there can be no excessive civilian harm as compared to the direct and concrete military advantage sought by the attacker, and the principle of precaution, which requires the attacker to take all feasible precautions to respect both the principle of distinction as well as the principle of proportionality. And what we see today is interpretations whereby there seems to be a tendency to minimize everything on the civilian side and maximize, if I can put it in very simplistic terms, everything on the military side. So for instance, of course, when you look at the definition of military objectives are defined, everything is a civilian object unless it is a military objective, right? And military objectives are those which by their nature, location, use or purpose provide a direct military advantage to the attacker in the circumstances ruling at the time. Everything else is a civilian object. Now, what we see very often is that civilian objects that are perhaps partly used or could potentially be used for military purposes in the future are already considered to be military objectives. Now, if they are used as military objectives, so for instance, if energy infrastructure is used directly and concretely for military operations, then it turns into a military objective and can be attacked. However, that is not the case just for energy infrastructure in abstract. There has to be at least a purpose to be used for military objectives. And what we see today is that very, very quickly, energy infrastructure becomes the object of military attacks. The argument being they turn immediately into military objectives, but it creates a complete devastation of the entire infrastructure with very little argumentation about whether this infrastructure is in fact being used or concretely intended to be used for military purposes. So that's, for instance, an example of the principle of distinction being really sort of put out of kilter, if I could put it this way, between military necessity and civilian and humanity. Similarly, the principle of proportionality requires there to be no excessive civilian death, injury, or destruction of civilian objects as compared to the concrete and direct military advantage sought. Now, already, if you've minimized what is a civilian object, of course, you don't need to take into account all those things that you don't consider to be civilian objects anyway. Another example here is, of course, hospitals and healthcare infrastructure. When hospitals are misused, when they are used for, the hospitals are obviously civilian objects, and they even have special protection, enhanced protection, if you will, under international humanitarian law. When they are used for acts harmful to the enemy, so for military purposes, to simply put, they lose their protection. Of course, they lose their protection. But you still have all the constraints of proportionality, precautions, etc. But hospitals are very complex entities consisting of, often many buildings, many structures, doctors, medicines. There are patients, civilian patients in the hospitals, or actually wounded and sick combatants who are also protected against attack, of course. And what we see today is the civilian harm anticipated when military objectives are destroyed is again minimized, in the sense that you can immediately foresee when energy infrastructure is destroyed that you will have downstream effects on, of course, energy, water supplies, hospitals, healthcare, contagious diseases, public health. And these are all foreseeable ex ante by the military commander. And yet the argument is often made, it depends, it's contentious, but the argument is often made that these downstream effects, second and third tier effects, don't need to be taken into account, or if they have to be taken into account as a matter of law, it is so difficult to take them into account that as a matter of fact, they're not being taken into account. And on the other hand, on the side of concrete and direct military advantage, where obviously already from the wording, it has to be concrete and direct. It cannot be military advantage in an unknown future. There you hear again and again, yes, but we had to win the war. Yes, but we had to defeat the enemy. Now, winning the war and defeating the enemy is not a concrete and direct military advantage of one attack. And so you see that if you minimize the civilian side of the equation and you amplify the military side of the equation, you end up with the conflicts that we see today. They are a consequence not only of blatant disregard for international humanitarian law, which we also see a lot, but they are also a consequence of the way international humanitarian law is interpreted. And that is something that, in terms of a legal challenge, has to be has to I think, be of great concern to those of us who deal with international humanitarian law. There's also a resurgence of debates on very old weapons, such as anti-personnel mines, and I'll come to that back in a minute. So at the same time as having these very destructive weapons, you also have new technologies of warfare that characterize contemporary armed conflicts. And I'll talk about two in particular. One is cyber operations. So the use of cyber operations in armed conflict situations. And the other one is the development of autonomous weapon systems. Now, what are the legal challenges here? For cyber operations, there's, of course, first of all, a challenge of classification of conflicts. And you will see in the challenges report that we published, we try to tackle the various wordings that you see in these hybrid situations. And there are, as a matter of fact, of course, a lot of operations under the radar, non-acknowledged, undercover, of very low intensity, of higher intensity. And there's a lot of talk about gray zones, about hybrid warfare. And so it's important, first of all, I think, just to say, international humanitarian law is very binary. Either something is an armed conflict or it is not. And if it is an armed conflict, it's either a non-international armed conflict or an international armed conflict. So international between one or more states, non-international between states or non-state armed groups, or states and non-state armed groups. And cyber operations can be categorized in those categories. It's just a question of being precise about what we are talking about. Certain cyber operations will be below the threshold of armed conflicts. Other cyber operations will happen already in the course of armed conflicts. And if they do, then they are a means and method of warfare, and they are subject to IHL rules, again, in particular, the conduct of hostilities rules, such as the principles of distinction, proportionality, and precaution. Now, that is actually still contentious in multilateral negotiations. As you know, there are negotiations at the UN about information and communication technologies, and there isn't agreement by everyone that cyber operations are actually subject to international humanitarian law. In particular, Russia is a country that rejects this notion. However, the great majority of states considers that, of course, IHL constrains cyber operations in armed conflict situations. And the question there then again becomes a question of interpretation. Because IHL will only really constrain cyber operations in order to protect civilians and civilian objects from harm, which is the object and purpose of conduct of hostilities rules. They're all there to protect civilians from harm, basically. Now, if you interpret cyber operations, for instance, to be attacks, then they are subject to Rule 49 of Additional Protocol 1, which is also customary law, and attacks are subject to these constraints. But some argue that cyber operations that don't destroy things, but just disrupt things, so for instance, disrupt the energy supply or disrupt certain services, don't amount to attacks and therefore are not subject to those principles. Now, if you interpret international humanitarian law this way, you will hollow out the protective effect that it is meant to have. And I think you don't really adapt it then to contemporary warfare situations. Similarly, what we see as a matter of fact is not so much things being, things as it were being destroyed, infrastructure being destroyed, for instance, or objects being destroyed. What you see a lot is attacks on data. And this can be, it goes from espionage to, just siphoning data or destroying data. Now, data traditionally, civilian objects traditionally are tangible objects. And this is also what the ICRC commentary to Additional Protocol 1 of the 1980s says. But of course, at that time, it wasn't foreseen that data, particularly personal data, would be of such importance in civilian life that it actually, of course, deliberately becomes the target in contemporary armed conflict. And so if we consider that the main target of these new technologies of warfare is the equivalent of what civilian objects, tangible objects used to be, then if you don't consider them to be objects in the meaning of international humanitarian law, again, you will completely hollow out the protective intent of international humanitarian law. Now, the ICRC, we proposed at the last international conference on the Red Cross and Red Crescent of last October, we proposed a resolution on information and communication technologies in armed conflicts. And it was really a landmark resolution because for the first time, in a resolution adopted by consensus by states and Red Cross and Red Crescent societies, you had an acknowledgement, first of all, of the humanitarian impact of cyber operations, which is something that we hadn't seen before in a multilateral forum. And secondly, of the fact that international humanitarian law and the principles that we just talked about apply to such conflicts. So it was really a very important new step for us. And I'll talk a bit about further work that we want to do about it afterwards. Now, just very briefly on autonomous weapon systems, these are systems that, can be attached to drones, but it can also be, of course, naval not vehicles, how do you say? Anyway, you see what I mean. It can be robots, it can be anything. Autonomy just basically means that the robotic system will choose the target without control by the human on the basis of a broad algorithm. So defining a certain category of persons or of objects that will be targeted, and then the weapon system itself chooses when, where to target its, to fire on its targets. Now, there's been a long debate for over 12 years at the United Nations, in particular within the conference on, within the Convention on Conventional Weapons meeting, about whether there should be a new legally binding instrument on autonomous weapon systems. There's been a lot of progress made to understand what are these systems, how do they work, what are their potential risks for humans. And the ICRC has come to the conclusion that the risks for humans are so high in terms of respect for international humanitarian law when you don't have a human in the loop, particularly if you have artificial intelligence systems, so machine learning systems that basically make the weapon develop in a way that you have not foreseen when you developed or launched the weapon. Ethical problems, as well as societal problems, that it would be beneficial and necessary and actually urgent for states to come together and agree on a legally binding instrument that doesn't necessarily prohibit all autonomous weapon systems, because some autonomous weapon systems can fairly easily probably comply with international humanitarian law. You see this a lot in, air defense systems, for instance, which already work with a lot of autonomy, and they are often in places which are quite empty of civilians, and they're also in very controlled environments, and they only target very specific incoming, missiles, for instance, so very specific military objectives. They're never targeted at humans, for instance. So those don't pose particularly grave issues, but others, of course, and in particularly those that will target humans, pose very big questions in terms of, on the one hand, compliance with international law. How can they really distinguish between combatants and civilians, but also in ethical terms, do we really want machines and algorithms basically decide on life and death? And so the ICRC has called for a treaty on autonomous weapon systems to, on the one hand, limit those that exist and prohibit some that shouldn't, in our opinion, be deployed at all. So that's the first part on, what are the big contemporary armed conflict challenges? And I've already talked for about, over 15 minutes. So just quickly on the second part on the main challenge to international humanitarian law that we see, which is basically the challenge of respect, lack of compliance with international humanitarian law. And as I said before, this is on the one hand based on simple disregard, not even an attempt to justify violations, very often denial of the facts by the parties. Parties will just simply say, no, we don't torture anyone. And of course, just denying the fact of what happens behind, prison walls, for instance. And more perniciously, and that's what I tried to describe before when I gave you these examples of conduct of hostilities rules, through justification of what justification of certain military actions through a very permissive interpretation of the rule, and argumentations basically also with exceptional circumstances. And that's not necessarily something new. It has always existed. You have had, always argumentations, particularly about terrorism. The argument, for instance, that we are fighting terrorism, but that's not an armed conflict situation, therefore IHL doesn't apply. Also, this non-state armed group is a terrorist group and we don't want to give it legitimacy, therefore we do not apply international humanitarian law to it. Or even if international humanitarian law is applied, you deny protection to certain detainees, either because they're terrorists or because they're mercenaries or because they're unlawful combatants. And so basically you define them outside of the, out of the protection of the law. We hear arguments that IHL is not made for wars of aggression, that IHL is not made for wars of self-defense, that IHL is not made for wars of survival. All these arguments are arguments that we have heard a lot, particularly in the last few years. And of course, all of this is exactly what IHL is made for. In particular, it is made for wars of self-defense because it's made for international armed conflicts, and international armed conflicts tend to be, at least on the side of one of the two parties, wars of self-defense. And usually the parties don't agree on who is defending itself and who is the aggressor. And so that's why it's so important that even within the troubled and broken down system of international law that wars represent, you keep this space for humanity and international humanitarian law, no matter what side you are fighting on, and for all, binding on all belligerents. I've talked before about the justifications under the rules on the conduct of hostilities. I'd perhaps also, and that's what I alluded to before, say that we are very concerned at the moment about certain treaties even being put into question as such. As you know, Lithuania announced its withdrawal from the Cluster Munitions Convention, which will come into effect this month. And the argument there was, well, it was a convention that we signed on when we didn't feel we were under a particular security threat, but now that the security threat is heightened and that we might face armed conflict, we cannot abide by this convention. But of course, the Cluster Munitions Convention was precisely made for situations of armed conflict, and we see with great concern now a debate about the use of anti-personnel mines. As you know, in the conflict between Russia and Ukraine, anti-personnel mines are being used. Russia, of course, is not a party. Ukraine is a party to the Mine Ban Convention. Anti-personnel mines have been transferred by the United States to Ukraine, even though Ukraine is a party to the convention, or at least have been announced to be transferred. And we have states that are now reviewing whether they should withdraw from the Anti-Personnel Mine Ban Convention. Now, again, these weapons are really weapons of past, they are really weapons of the past. There's a lot of research of their military utility, finding that they are not really of great military utility, but mainly also that the limited military utility that they have is in no proportion to the huge and devastating humanitarian impact that they have. whereby the great majority of people killed and maimed by anti-personnel mines remain civilians, continue to be civilians, because these weapons cannot distinguish between a combatant and a child. That is just how they are. They are victim activated. Whoever steps on them will be blown, will be subject to its impact, and the weapon does not know, the mine does not know who steps on it. So that's, I think, of great concern today, and we are in a moment where we have to really fight, I think, for international humanitarian law. We were probably always in such a situation. Probably all of us who are in this job always feels that our time is the worst time and that we have to fight the most. So I won't pronounce myself on this, I don't know. But we have to ask ourselves always what can be done, what more can we do to achieve better respect. It is the critical question of international humanitarian law. And I think all our discussions on legal challenges can never divert our attention from this core challenge, which is really the most important one. And from our perspective, and also in our experience at the ICRC, international humanitarian law respect has to start with implementation by states in the domestic realm. So it starts with ratification of the treaties, and you know, the Geneva Conventions are universally ratified today, but this is because the ICRC forever has been advocating, you know, with every single state for its ratification, and has even been given a mandate in the 90s by states to work for the universal ratification of the Geneva Convention's additional protocols. And then to have the laws in place in the national systems to make IHL a reality, because you can have the best political will to implement international humanitarian law. If you're not prepared in war with your legislation, with your policies, with your rules of engagement, with your systems, for instance, to account for the missing, to restore family links, to account for the dead, you will not be able to comply with international humanitarian law. So you need the laws in place. International humanitarian law also foresees, of course, that legal advisors should be in the armed forces in order to give legal advice to commanders about respect for international humanitarian law. You need criminal laws, and you would be surprised how many states legislation still lack proper criminal sanctions regimes for violations of international humanitarian law. You need training of the armed forces, and we know from research, and it's very interesting because there's more and more sort of social behavior research that shows how training has an impact on the behavior of armed forces. So training is definitely worth investing in, proper training, of course, done well, but also education in the broader public, because if you want states to be strong, governments to stand strong in situations of strain, of pressure, to abide by international humanitarian law, it has to be something that's anchored also in the society and in the values of the society and the state. Non-state armed groups can also comply with international humanitarian law. And there too, it's very much worth investing in better compliance by non-state armed groups, because as I said, the great majority of conflicts are still non-international armed conflicts. Armed groups can also have their own documents, codes of conduct, rules of engagement, and they have to, in the first place, comply with international humanitarian law. There too, there can be training, there can be dialogue, there can be bridges sometimes when these groups are particularly embedded in certain societies, in certain cultures, in certain religions, in order to build bridges between international humanitarian law and those cultures. And then beyond the sort of domestic realm, of course, there's an obligation to respect and ensure respect for international humanitarian law, whereby all states, not just the belligerents, have an obligation not just to respect, but also to ensure respect for international humanitarian law, which goes from not encouraging violations in the first place, all the way to taking feasible actions to bring the belligerents towards an attitude of respect for international humanitarian law. And that's certainly something where much improvement can still be seen. All states have a stake in respect for international humanitarian law, and all states should step up and not just denounce the violations by the enemy, but just work with their allies for better respect for international humanitarian law. That's the difficult part, but it's also the part that can really make a difference, because you're not going to have much influence over your enemies, but you will have influence, if you want, over your allies. And that starts, of course, with any sort of political support, financial support, but also, of course, weapons transfers. And as you know, many states are party to the Arms Trade Treaty. European states are subject to the common position on weapons transfers of the European Union. And certainly there much more can be done. And as we saw recently, there's a lot of litigation as well, of course, around weapons transfers to look much more closely into whether the transfer of certain weapons will contribute to violations of international humanitarian law or not. Again, I want to mention the resolution of the International Conference of the Red Cross and Red Crescent. So there was one resolution that I already talked about on information and communication technologies. There's another resolution which is entitled Building a Culture of Compliance with International Humanitarian Law. And in its operative paragraph 10, the resolution, and I'll read it, it's a very long paragraph, but I think it's really a landmark paragraph that is very useful in terms of what states agreed to in this resolution. And again, by consensus, it says, the International Conference insists that states refrain from encouraging, aiding, or assisting IHL violations by other states and act to promote compliance with IHL by other states in conformity with international law and the UN Charter, including by convincing parties to armed conflicts to put an end to IHL violations, seeking the commitment of states at the highest levels of civilian and military leadership to comply with IHL, helping states build their capacity to implement IHL through the development of military doctrine, training and mentoring, and other appropriate means, assisting states in ensuring that their judicial and administrative bodies are capable of effectively addressing IHL violations committed by their own forces, and holding persons accountable in accordance with applicable requirements of international law, assisting states in strengthening their national IHL committees, and so on, complying with their own obligations and laws regulating the use and transfer of arms, and using diplomatic dialogue, humanitarian diplomacy, and other appropriate measures to promote compliance by other states. And furthermore, urges states, where appropriate, to promote compliance with IHL by non-state armed groups. So I'm reading you this very long paragraph just to show that this is really something we can build on and have a dialogue with states about what are you doing to better achieve compliance with international humanitarian law. And this leads me to my very last point in this part about what can be done. You need two things, basically, for respect, probably of all international law, but particularly of international humanitarian law, which is, on the one hand, you need the structures, you need the treaties, you need the structures, the laws, but you also need political will. And you need political will at the national level, at the regional level, and at the multilateral, the universal level. And the ICRC last September launched a global initiative to improve and strengthen political commitment to international humanitarian law. It's an initiative that we launched together with 6 states from different parts of the world. The 6 states are Brazil, China, France, Kazakhstan, South Africa, and Jordan. And these 6 states and us felt that we need to redouble the political commitment to international humanitarian law, and to bring all states along, because all states have a stake in better compliance with international humanitarian law, also because not only the human, but also the social and global economic costs of armed conflict are not only unacceptable, but they're also unsustainable. Armed conflicts are expensive. They lead to de-development, if you can put it this way, although it's not a very good word. And they set the entire world back. So what we will do is we will have this initiative over 2 years. It will culminate in 2026 in a high-level meeting on compliance with or commitment to international humanitarian law. And in those 2 years, we will work along 7 work streams, so 7 subjects, if you will, of international humanitarian law, which will lead to concrete recommendations that we want to submit to this meeting of hopefully all high contracting parties to the Geneva Conventions. We will see who is interested in this initiative. The 7 work streams are, on the one hand, 3 work streams on what I talked about now is basically building compliance, building national IHL committees, better prevention, building the bridge between IHL and peace. 2 subjects that really have to do with the devastating and very urgent problematics that we have today, which is on the one hand, the protection of civilian infrastructure, and on the other hand, the protection of hospitals in armed conflicts. And 2 last subjects, which are about contemporary and future challenges of armed conflicts, and which are specifically about information and communication technologies. And so they build on the ICT resolution that we had at the conference, and also on naval warfare, because that's sort of what's looming on the horizon and which we feel needs an update and a deep thought in order to have good recommendations for states to preserve humanity also in naval warfare and in all of these conflicts. So I'll leave it at that. I'm sorry I spoke for a very long time, and look forward to any comments, criticisms, questions that you might have. Thank you.
Thank you very much, Cordula. This was very, very rich. Thank you very much for presenting several salient points of the report that we identified about contemporary challenges. I can see in the chat we have a couple of questions. I would say that all the questions, at least 3 out of the 4, they share the same trend. And the trend is, what can we do? And by we, it's different communities of practice to enhance, for example, the principle of necessity that comes from Sarah Kay regarding the role of legal practitioners. Or Duru also asks about how can we contribute into state compliance with IHL amid shifting geopolitical strategies, and to what extent other methodologies of empirical research, strategic policy advocacy, engagement could help. So you see, we're talking about different epistemic communities and different methodologies of intervention. Sorry. And there is another question, sorry, from Maya, who asks in particular the role of civil society with open source intelligence for the documentation of serious violations of international humanitarian law, including war crimes. And how do you see the position, whether the ICRC thinks there is a need for further legal framework regarding the admissibility of that type of evidence? Maybe I can stop here and then keep collecting other questions. Is that okay with you?
Okay. So first of all, on what can be done, and again, as I said, and that's why I read you this long paragraph, I think a lot can be done, and I think various groups of people, practitioners, researchers, academics, civil society have something to contribute and have a role to play. There's a specific question here on empirical research, and empirical research can be very useful. As I said before, there's some behavioral science research on what drives belligerents to comply with the law. The ICRC, for instance, published this report called Roots of Restraint in War, and it analyzes what is it that makes either state armed forces or in particular non-state armed groups exercise restraint in armed conflict situations. There's also some research recently published, I think a couple of months ago on our website, about the effect of training and the correlation between IHL training and the protection of civilians, or rather the diminishing civilian harm in armed conflict, which shows quite clearly that there's a correlation, that the more IHL training you have, it has an effect on diminishing civilian harm. So I think behavioral science, social science, etc., are very important. In our work stream that we will do in the global initiative, one of the aspects that we look at is prevention methodologies and good practices, and we will draw not only on research on prevention in IHL, but of course there's other areas of the law where prevention and what works in prevention has been analyzed. So for instance, on torture prevention, what works in terms of torture prevention or not. So it's very useful to have this kind of research. Also about, do legal arguments make a difference or not? And, some people make some research as well on the effect of legal arguments on the restraint by belligerents. Then in terms of other practice, I mean, the ICRC is a humanitarian organization that doesn't get involved in litigation or in contentious conflicts, also because of our way of working, which is in dialogue with all parties to conflict, and our preferred methodology, which is confidential bilateral dialogue. But of course, there are many other actors that have different ways of working, and there are many, in fact, mechanisms in which IHL is being either litigated or analyzed. So for instance, if you look at the human rights mechanisms, very often IHL questions come even before the human rights courts. And so you really have litigation also before the International Court of Justice, of course. You have a lot of commissions of inquiries, you have UN treaty bodies, the human rights treaty bodies. Many of them analyze aspects of IHL. And I think what's really interesting there, I mean, beyond, of course, the specific case, which can be sometimes very beneficial, particularly if you have a victim of a violation that might get some justice. But beyond that, it also creates a densification of the entire legal framework of international humanitarian law. It clarifies it. And interestingly, you can see in all these different bodies I find quite interesting convergence about the interpretations and about what is expected of belligerents. Of course, there are small differences here and there about interpretations and for instance, about the relationship between human rights and IHL. But by and large, you have a lot of mutual reinforcement of these various mechanisms that lead to, a density of this body of law that's, I think, contributes to its protective force, although I think it also contributes to sometimes backlash. And the backlash that I was talking about and the interpretations, I think, are also in a way a consequence of the success of this body of law. And the development of this body of law, for instance, through tribunals like the ICTY, and perhaps states, in the 1970s when they agreed to the additional protocols, or in 1949 when they agreed to the Geneva Conventions, didn't foresee all that would be this body of law in 2025. Although I would argue that by and large it is very much still within the realm of the rules that were agreed so long ago in the 40s and 70s. The role of civil society is, of course, very important. I think I mentioned it. A particular question about, again, civil society in terms of not just through new technologies, but just civil society bringing attention to violation, bringing attention hopefully to the victims of those violations, also sometimes helping people to access certain international instances perhaps that they might not necessarily have accessed, and etc. So I think civil society is of course absolutely critical, just to bear witness to what is going on, to do the reporting, to do the evidence gathering. In terms of, do we need a new legal framework for the admissibility of evidence? I must say I wouldn't have an answer to this, because, as I said, the ICRC, although it has very much contributed also to the fight against impunity. So, for instance, the Rome Statute of the ICC was also something that the ICRC supported. But as we don't get involved in particular cases, I wouldn't have an opinion on the evidence being accessed in those or being used in those instances, in those criminal instances.
Thank you very much, Cordula. If we can get another round of comments and questions. I think there is a question that was also in my mind. You spoke about this trend of permissive interpretation, but actually we also see a trend of total defiance of international law, lack of ignorance or dismissal of international law / international humanitarian law. So there is a question how this current developing political context by particular state might affect this request for compliance, the need for compliance with IHL. That's one question. There is another question which is more particular about the protection of civilians and regarding within the urbanization. We talk about the urbanization of armed conflicts. And the question is about the revolving door problem, about the direct participation in hostilities and how this further urbanization of armed conflicts actually contributes into those challenges regarding the protection of civilians. And maybe if you would like to comment on that, of course, we have the interpretive guidance from the ICRC. But it's very true that the last years we have this further, it is a challenge, the urbanization of armed conflicts. So I was wondering also myself how that comes together with the overall political context / several attacks on humanitarian organizations that operate in this environment. So I stop here. Thank you.
So yes, the problem of total defiance or denial or rejection of the legal frameworks. Again, I think that's not something new. We've seen it by certain belligerents, either states or non-state armed groups, although I would say most states, all states even, at least pay lip service to international humanitarian law. So states don't say that they don't abide by international humanitarian law or that they reject international humanitarian law as a whole. As I said before, they might reject some of the conventions now, and that should be a huge concern. And I've had discussions with many colleagues. Is it better if you just deny that you're violating the rule because you're denying the facts? Or is it better that you reject the rule altogether? Or is it better that you agree with the rule but argue within the rule that you're actually, that the rule is so broad that what you are doing is justified? And I think that's quite a difficult question to answer. But what I would say is, when you have states that justify what they do within an accepted framework, a multilateral, an international framework, and as I said, in the case of the Geneva Conventions, a universally agreed framework, you are still within the framework. And there is scope for dialogue and there's scope for contention. And interestingly, I would say that the vast majority of states will react to such justifications by rejecting them. And so perhaps unlike a national system, which, in a way is smaller, and in a national system, you can have the entire rule of law either immediately or gradually being undermined. An international system is perhaps slightly more resilient because it is made of far more states. And states don't always have the same interests, the same indignation about the same violations. And so perhaps the rules cannot be so easily completely eroded and undermined because you have voices that speak against the undermining and the erosion of such rules. What happens, though, is that at least in the Western world, we tend to perhaps hear some voices more than others, and the voices of some states more than others. And perhaps it's time for us to listen a bit more to all the states and to what all states have to say, because international law is not what some states think. It's what all states, or at least the great majority of states, think and how they interpret. And so I think that by and large, we have to hold on to the frameworks that we have and try to preserve them and fight for them and uphold them in good faith, with good faith interpretations as required by the Vienna Convention on the Law of Treaties, in order to achieve their protective object and purpose in the case of international humanitarian law. The question about the urbanization and the revolving door, I'm not sure the two are necessarily correlated, but I think I see what you mean, because what you're saying, I think, is that in an urban environment where you have a lot of co-location between combatants and civilians, you might, of course, have more direct participation of civilians in hostilities, and then perhaps moving out of the direct participation and then being involved again in the hostilities directly. And we see this, and I wouldn't say it's so much a question of urbanization, but it's also a question of new technologies, and we see it as well with cyber, of course, and information and communication technologies, because there we might have more and more civilians getting very close to hostilities, but perhaps if you have, if you just transmit, let's say, military intelligence through an app, you might be in that particular moment directly participating in hostilities, but then, of course, the moment you don't transmit this information anymore, you're not participating in hostilities. Now, I think that example, for instance, shows very clearly that if we want to be serious about the protection of civilians, then we also have to be serious about the wording of international humanitarian law, which is that civilians lose their protection against attack until and for such time as they directly participate in hostilities, which means they only lose their protection against attack for the time that they participate in hostilities. They then regain protection against attack as civilians, and they might lose it again if they directly participate in hostilities again. But I think we just have to take the wording that was agreed by states seriously, and again, not erode the protective scope of international humanitarian law by saying, no, but now we extend the for such time to say, well, even in between, you will be targetable, because that's not what the rule says. And so I think that's precisely one of the examples I want to give, again, about the erosion of the balance found here between military necessity and humanity. Humanity requires you to protect civilians. Military necessity allows you to target them when they pose a military threat. Once they don't pose a military threat anymore, they are protected again. And then there was a link between to the attack of humanitarian workers. I'm not sure. I mean, humanitarian workers indeed have, in 2024, been the subject of the most attacks ever recorded. A lot of that has to do with two particular conflicts. One is the conflict in the Gaza Strip, and the other one is the conflict in Sudan. Sudan is also a very, very dangerous place for humanitarians, but I wouldn't want to make a correlation between the revolving door. I think that's a very dangerous argument to make. There are, of course, sometimes and far too frequently, for instance, misuses of the Red Cross and Red Crescent emblem. And that, of course, can create a risk for humanitarians, because they will then, no one then knows, okay, is this really, an ambulance? Is it not an ambulance? Is it really a Red Cross, Red Crescent convoy? Is it not a convoy? But I would say on the whole, the attacks are not necessarily linked to that issue.
No, the question about the humanitarians was irrespective, was independent.
Okay, sorry.
So no, it didn't even. It was just one of the challenges in the report also that you mentioned.
Absolutely.
that's what I thought it should be highlighted also, how humanitarian officers are in danger, and there is an increase, as you mentioned, on attacks. And Cordula, if I may ask a final question, I think I can take it from one student. Between the two latest reports, one, if I'm correctly, was in 2019, right? And the other one, it was 2024 in September. So we have a 5-year period between the two reports. We have other conflicts, some more visible. You mentioned Sudan, which is, of course, for you as experts, is very much visible, but for many, not so visible for others. But what would you say, what are the points that you think they are the most different in the 2024 report from the 2019? What are the key issues that you wanted to highlight, to bring into the surface more?
I would actually say, and this, we discussed it very much with my colleagues, there's a real continuity actually between the 2019 report and the 2024 report. And the reason why there are 4 years in between is COVID. That's why, 5 years, because we didn't have the conference in 2023. The continuity is already in 2019, we talked about the urbanization as one of the key trends, and that's continued, and that was evident that it would continue again, because if people move into cities, then so will wars. The other trend, of course, that we talked about in 2019 was the new technologies of warfare, and so it just becomes in 2019 it was perhaps still more a bit. It was already, cyber operations already occurred, but I would say it's really become much more evident in contemporary armed conflicts that this is a reality of all armed conflicts now. And I only talked about cyber warfare, but there's also, of course, the whole use of artificial intelligence in military decision making, which I think we saw less in 2019 and which has become much more evident now. But in a way, there's a trend of new technologies which has just been exacerbated, I would say, and where perhaps some of the effects we wouldn't have thought about so much. So, for instance, this involvement of civilians in the ICT, which is, of course, when you look back, completely evident, because ICTs are mainly run also by private companies, and civilians are easily accessing them. So it's a heightened risk, but I would say it's a trend. Not a change. And then I would say also respect and compliance. All our challenges reports have always had an aspect about respect and compliance. I would say the things that have really marked the last 2 or 3 years in particular, of course, very much the conflict between Russia and Ukraine and this resurgence of international armed conflict. And I will tell you, you might know that the ICRC has a project to update the commentaries to the Geneva Conventions, because the commentaries date from the 50s and 60s. And we published the commentary to the third Geneva Convention on prisoners of war in 2021, I think, or was it in 2020? I can't remember. Anyway, it was before the conflict between Russia and Ukraine. And at the time, we had like a few prisoners of war around the world. And perhaps some people thought, really, do you really need to publish a commentary on the Third Geneva Convention about prisoners of war? And look what's going on now. And look what also states are preparing for. And it's very interesting. The world is almost preparing for international armed conflict. You have defense budgets augmenting, of course. You have the tensions in the South and East China Sea, etc. And that is something that I think we see more and more with great concern. And it's something that we at ICRC think, on the one hand, of course, it means you have to, if you're going to prepare for conflict, you also need to prepare for the humanitarian aspects of this conflict. So you need to prepare for the fact that you will have missing persons, that you will have great amounts of death, that you will need to detain people, etc. But on the other hand, we really hope that states will put as much effort into preventing conflict in the first place, because the humanitarian consequences of conflict, and this is something that we can speak to as a humanitarian organization, are such that really we will not be able to bear the human, social, and economic costs of more conflict and greater conflictuality in the world. So that's really why we hope that we are, avoid, and we really need to try to avoid these conflicts. And I would say that's something that I think is on everybody's mind now. And of course, it's also on the mind of the ICRC. And then the last thing I would say is about certain weapons. So I talked about this withdrawal or discussion of withdrawal from conventions. That's something we have not seen before. Very worrying, and that we must absolutely try to counter. And the other one is, and this is the first time in a challenges report that we mention nuclear weapons. The ICRC has always called for the abolition of nuclear weapons since Hiroshima, where we were present. And of course, we worked before 2019 already on the adoption of the treaty for the prohibition of nuclear weapons, which then came into force in 2021, which was really a moment to celebrate. But the danger of nuclear war is immense. People say it's the highest since the First World War, and it's just augmenting. We see nuclear weapons being playing again a greater role in military doctrines. The taboo seems to sort of be more and more eroding about the use of so-called tactical nuclear weapons, and that's something again that we see with great concern.
Cordula, thank you so very much for this very insightful presentation and discussion, for addressing all the questions and comments of the participants. It is very, very important to have, it was very important to have you today to talk about these contemporary challenges. It's true, we live in challenging times. And thank you very much also for the message of continuing effort, I would say, with all our means, from all, wherever we come from, whether we are academics or legal practitioners or advocacy groups, to keep trying, push for more compliance, more respect of international humanitarian law, in order not to lose sight, as you say, of the essence of international humanitarian law. On that note, I would like to thank you once more very, very much, and we hope to host you sometime soon here in London. Thank you once very much.
Thank you very much for inviting me. Thank you.
Thank you. Thank you all for attending, and hope to see you in our next webinar. Thank you all very much. Have a good day. Thank you. Bye-bye.
Bye now.
Bye-bye.